with regards to the need for structure. Yes, please go ahead.
Sorry, what is the what is the question I should go ahead on? Sorry, if you can refresh my memory.
That's all right.
About the question that was being asked.
That's fine.
When was being answered.
We were reflecting upon section 201, and I had indicated that what is referred to as the marginal note, perhaps more appropriately the header note, provides for the presiding commissioner. Now, subsection 1 speaks of only the presiding commissioner and provides for the qualification of a person that holds that position, whether presiding or a sole commissioner. And then subsection 2 speaks of when there are more than 2 members, one of the commissioners needs to be a subject matter specialist in the subject matter of the inquiry. And we were reflecting upon 201 because I had wanted you to enlighten myself and the committee on the distinguishing between an establishment and a mechanism. Of course, you had clearly given us what you understood to be an establishment, that it more often is provided for by statute for permanence. It is captured in the budget process. In its operations, it can develop committees and etc. We were going on to make the distinction and speak on a mechanism. Is that fine?
Yes. Now, we were talking about whether the fact that there's a chairperson, if I understood your question, made any difference. And my answer is, doesn't make any difference. Now, if you look at the chapter on commissions of inquiry, which is chapter 18, in tandem with the Act, which breaks it down a little further, you will see that in sections 1, section 2, subsection 3, it provides, that's of the Commissions of Inquiry Act. It says the commission shall specify the subject of inquiry and may.
My apologies. Are we reading the Constitution or the Act?
The Commissions of Inquiry Act. I'm trying to read them in tandem.
Sure.
Because the Constitution is a bit succinct, and understandably because it expects that there will be an act, and there was an act which predates the commission in fact, and which would have been taken into account when the Constitution was being drafted.
Very well.
So if you look at the Commissions of Inquiry Act, sections 2, subsections 2, that's where the role of the chairman, the issue of the chairman is explained. It says, the commission, meaning the commission issued, that document that the president issued is referred to as the commission. The commission shall specify the subject of inquiry and may, in the discretion of the president, if there is more than one commissioner, direct which commissioner shall be chairperson, and direct where and when the inquiry shall be made, and the report thereof rendered, and prescribe how the commission shall be executed, and may direct whether the inquiry shall or shall not be held in public. So all the words that are being used, how the commission shall be executed, means it's a mandate. It's a mandate giving to 1 or 3 people to go and carry out a particular investigation. It's not trying to set up an office. An establishment connotes an office, which is then established, and it's given a structure, and of course, it will also have its own functions, and it may be permanent. But of course, we know there are establishments that can be set up for a short period, for a fixed period. But normally, establishments are permanent. So if you look further at subsection 3, the proviso, which says, provided that the presiding commissioner is entitled to, no, sorry, that's not the one I was looking for. The casting vote as a section.
But I would,
section 8.
if we could read that, before we
one?
go to subsection 3. Except
Okay.
as may be ordered by the presiding commissioner to exclude any particular person or persons for the preservation of order, for the due conduct of inquiry, or for any other reason.
Yes.
Okay.
What about it? Sorry.
I just wish for us to make a mental note of it. We can proceed on to 8.
Okay. If you look at the only other role, the commission, obviously, if you have more than one person, you will need to have someone taking care of or in charge of operational issues. You can't have 3 people. They are likely to waste time if you have all 3 people having to arrange the operations of any function, any committee, or whatever you
I agree.
establish.
I
Yeah.
agree.
So there must be a presiding commissioner. Is there if there is more than one?
Of course.
So that's logical. So, but one other, I think we can call it an authority that's vested on the presiding commissioner is the casting vote. If the commissioners are in any case equally divided, this presumes that they are 4. Maybe they are an even number instead of.
Yes, there could be 2.
There could be 2, and therefore, one of them, the presiding commissioner, is given a casting vote.
Of course.
Obviously, the mechanism that was issued in terms of our own, the one we are talking about, the Jane Commission, there are 3 commissioners. So the issue of the casting vote never arose. So the commissioners are equal. But always, we have this maxim, equal inter pares. It's just like a panel of judges. They're all equal. They have to decide, sit down, and agree on a consensus as to the way forward. I assume when it comes to this committee, they are all equal. I don't presume that that's in the nature of committees and presiding officers of committees. But it has no effect or impact in terms of determining or whether the Commission of Inquiry is an establishment or not. The Commission of Inquiry cannot be an establishment because the language that is used in setting it up, it's issued. It's just a commission that is issued. And then the persons who are appointed as members of the commission are called the commissioners. By virtue of the fact that it's a commission, it's a commission, a commission is a mandate. And the other word for commission is a mandate. A mandate given to 3 people to go and investigate a particular matter. And once they are done, they are functus. As soon as they submit their report, they are functus. They cease to exist. So, and that is if you look at the TOR of the commission, it's there that as soon as they submit their report, they become functus, and that brings them to an end. So that's why they are a mechanism, they are not an establishment. Establishments have to be wound up. When they finish what they are doing, they have to be wound up. And so it's an entirely different kind of tool that that's being used. And I think I'd just like to
Is that it? You done?
yes.
Okay. I'll contend with you on that, Ms. Bensouda. I will agree with you that perhaps it is a mechanism and it's not an establishment. We can agree largely on that. I don't see too much of a difference. But with respect to the issue of structure and organogram, nothing that we have looked at in the law suggests that a mechanism cannot have a structure or an organogram. In fact, I would argue the opposite, that everything we have read points to a structure, that that even though there were 3 commissioners, there was one commissioner who was appointed to be the chairperson. And as such, the privileges of a chairperson would accrue to him as the presiding commissioner. And we would see that in section 2(3) of the Commissioners of Inquiry Act, but we would also see it in section 201 of the Constitution. And since we're talking about the structure of the commission, I would like us to be clear on that before we move on to other issues. That indeed there were 3 commissioners, and I would again agree with you that in the exercise of their discretion and deriving at decisions, of course, they're all equal. But to state that all 3 commissioners are equal in a blanket manner, I would certainly contend with. I do not agree with that narrative, and I don't think the committee would agree, because even amongst the committee members, since drawing from your example, there's a chairperson, and that chairperson has powers. Powers of presiding, powers to interject, to determine admissibility, all those admissibility of questions, of course, Ms. Bensouda. All those lead to the commissioners or the committee members not being entirely equal. Again, I will repeat that they could be equal in decision making, such that no one committee member or commissioner can influence the decisions of the other. That I can agree. But to state that all 3 are equal, I contend with. And I would submit that nothing you've said, nothing in the law that you've quoted supports your argument, but rather goes against the grain of your argument, in fact. Can you comment? If you don't wish to comment.
I'm kind of at a loss, because perhaps it's because I'm not quite sure about the rules of procedure before this committee. Obviously, this committee is not a court. So it's certainly the view that council holds may be important when the committee comes to decide. But in terms of my evidence, it's not adversarial. It's not me against you or me against a subject. So I don't have to agree or disagree with you on anything.
You don't even have to comment.
So I don't even see the need to have anything in contention between us. My opinion was sought.
That's fine.
And that is my opinion. And if I may just make a slight comment on something you said, which I don't think is accurate, perhaps in this committee, but in the commissions of inquiry, which are kind of modeled on, for want of suppose a better mechanism on how courts operate. The chairperson does not decide on his own. The chairperson must consult the members, even on admissibility. If there is an argument before the Commission of Inquiry about anything that needs to be admitted, he would consult. He would turn to both commissioners on either side and consult with them, and they would have to agree with every single decision of whatever nature before the Commission of Inquiry. So it's not a situation where the chairman can override and say, this is what I think, and that is what would apply. So I'd just like to correct that. But apart from that, if you do have an opinion, that is fine. But as I said, my evidence, my opinion that was sought is that commissions of inquiry are not establishments, they are not offices, they are mechanisms.
So that's precisely what I'm saying. The point has not been made. At least I don't believe the point has been made. I would leave the rest to the chairperson and the committee. But also I would contend with you again that the all the commissioners need to be at par and need to be in agreement before a decision is made. Then what is the essence of Section 8 of the Commission of Inquiry Act, the casting vote, the overriding vote? When they are at a deadlock, the chairperson can override the decision.
Precisely, the casting vote is precisely that. When you have an even number of people and they cannot decide, then you have a deadlock because the number is even. So if you have two people and they don't agree, there's a deadlock and there's need for a casting vote. When you have 4, 6,
and that privilege
8,
is given to the
but
chairperson.
only even when you
Yes.
have even numbers. Obviously, if there's a deadlock, that would be the end of the commission. They will not be able to proceed. So that's why, again, these mechanism which exists not only in commissions, it exists in any decision-making body of people where you know, there cannot be there's an even number of people, and therefore there cannot be consensus because of the fact that the numbers are even. One person is giving a casting vote.
Yes.
So that doesn't mean that that person is necessarily more powerful than the others. It's just, again, I hate to keep on repeating mechanism, but it's a legal mechanism built into corporate, the law by which corporate entities operate, and you'll find it in the Companies Act, and you'll find it in different statutes. You cannot set up a body of people and not make sure that they will not come to a deadlock on any matter, and that will defeat the purpose or the reason why the body of people are being set up.
Of course.
And that's why you have this casting vote. But it has nothing to do with structure, and it has nothing to do with...
perhaps let me ask one question. In corporate culture, who is that casting vote given to?
It's always given to one person among the
And
group
who is
of
that
people.
one person?
It's given to a chairperson.
It's always the chairperson. That is structure, Ms. Bensouda.
I
Anyway,
think we're talking about two different things.
perhaps.
We have drifted away from the establishment.
Yes,
let's
we
leave
have.
it at
We
that. Let's leave it at that. I think we have drifted away from that. As I said,
we're still within
in
our.
terms of establishment, the language is very also important. Language is important. Establishments are.
Can you dilute on that?
Yes. Establishments are established. And when something is established, it becomes a body of people that is given some legal recognition as an entity. Commissions are not entities. They don't have any legal existence. So they are just mechanisms. They're just mechanisms. And whatever they're doing, when it's over, they're functus. That's the end of it. So.
Okay, just to also clarify a point, I did not mention once that the chairperson influences the commissioner's decisions. In fact, on the contrary, I did state that I would agree with you that when it comes to decision making, the commissioners would be independent. But to say that they're equal in every respect would be an injustice to the chairperson.
Oh.
But we can move on.
Learned counsel.
Yes, Learned Senior.
You know, there is a way the law operates.
Of course. I believe I've been oriented to some degree.
So when you have a body of people, they cannot all speak at the same time. So you need them to speak through someone, one of them. And that is why you have a need for what we call a chairperson or a presiding officer. Because they consult each other, and one is selected among themselves to speak on their behalf, to convey what they want to do through that person. So the chairperson is just a spokesman in those circumstances. They decide every decision, not only big decision, every small decision, they have to consult and agree, and one person speaks for them. He doesn't speak on his own behalf. He speaks on behalf of the group. So that's the role of a chairperson, is akin to a spokesperson. Otherwise, it will be chaotic if every member of a group has to speak on the same issue. So they speak, they consult, and then one person speaks on their behalf. That's the role of the chair. But it does not make the chairperson more important than the rest. It does not vest in the chairperson a power that is different or separate from the rest.
I believe
perhaps
that is the point of our contention. Perhaps I would take your advice and say, we can move on. We're at a deadlock. I don't believe we would agree. I would direct you again to section 2(3) of the Commission of Inquiry Act, and I'll put it on record again. It says, except as may be ordered by the presiding commissioner in the public interest, public safety, or public order, the proceedings of the Commission of Inquiry shall be held in public. But then it goes on to say, provided that the presiding commissioner is entitled to exclude any particular person or persons for the preservation of order, for the due conduct of the inquiry, and for any other person. So my position, Honorable Chair, is that the chairperson has a distinct role from the other commissioners. They are the masters of the proceedings. They ensure that the conducive conduct of the proceedings, and in some instances, the Act bestows upon them specific privileges and powers that are not resident in the other two commissioners. So unless you have a comment, Ms. Bensouda, I would contend with you on that, but we can move on since there's no dead end to this conversation. Should we move on?
the proceeding is in your hands.
Yes, I had given you the option.
As I said, these are not adversarial proceedings. You know, it's not me against
Certainly not.
me against you or me against the committee. It's a fact-finding committee, as far as I know.
If it were
As a witness, once I give my opinion, that should be the end of it, and we proceed, because you have the privilege of working with the commissioners, the committee members, and giving them your opinion.
Indeed, but I feel I have a duty to put my opinion on record, especially where the record, I believe, has been tainted by another opinion. I use tainted in a very light word. There is no malice intended.
I suggest you don't use the word tainted because it does have a
As you
specific
please.
negative connotation.
Okay.
Yeah.
I could not convey it with any other word, but excuse me for that. But I would also say that you are also a witness that guides the committee, and where I feel the committee is not guided, I am at liberty to probe into it, albeit an opinion. Okay. The issue we were contending with, and before I proceed, Honorable Chair, if you permit me, Ms. Bensouda, it is indeed not an adversarial proceedings, not between you and I. In fact, if I had the option of picking a fight, I would pick a fairer fight. So indeed, it is not me and you. It is all to get facts for the committee. But moving on, we were discussing the difference between an establishment and a mechanism. And your testimony is that the Commission of Inquiry is more of a mechanism, because once it fulfills its mandate, it becomes functus. And still on the organogram, perhaps we can move, we agreed that the Secretariat would have an organogram. We are not agreed on the hierarchy of the commissioners. Perhaps let's move on to your responsibility. It is from evidence we have obtained in this committee, from yourself and other witnesses, namely the chairperson of the Janneh Commission, as he then was, the Honorable Doyen of the Bar, Mr. Janneh, as well as the secretary to the commission, the first secretary to the commission, Mr. Alhaji Mamadi Kurang, The second secretary also confirmed that. And just yesterday, another commissioner, in the name of Commissioner Abiose George, confirmed that as lead counsel, your role was to coordinate between the legal team and the investigation team. Their evidence is that you are in fact the head of the legal team and the investigation team. What do you have to say to that?
Firstly, my role was more than that, and my role is set out in my engagement letter.
We will get to your engagement
letter, I set out what I understood my role to be, and
Can
that
you permit me
engagement
to-
letter is was shared with the commissioners.
Indeed it was. MOJ
Now-
3K, Honorable Chair. If you would permit me, Ms.
Now,
Bensouda.
if I may just say,
If
there
I
was-
may, Ms. Bensouda,
I
kindly
thought
permit me.
you asked a question, or you
I
don't
did,
want an
but I want
answer?
to guide the question. I don't want to leave it in the open. The question is not with respect to your role in entirety. The question is with respect to whether you were the head of the legal team and the investigation team. So if we can confine it to that so that we can move on.
No, I was not head of the legal team. I was the legal team. I, as lead counsel, was the legal team. If you look at my appointment letter and my engagement letter, it said so. It said that and if I may quote from it, paragraph 4 of my engagement letter says, responsibility for advice and services. Services under this letter will be my sole responsibility. No other entity or individual accepts or assumes responsibility or has any liability to the ministry or any third party for the services provided under or pursuant to these terms of engagement. I was the lead counsel. Perhaps the term lead is a bit misleading. I was counsel to the commission, and there were other counsel, but they were all assisting me. So there was no question of their being head of a legal team. The legal team worked under me, under my direction completely.
Certainly, there is no question
Now-
because you were the lead counsel. So you were leading all the rest of the council. You were the head of the legal team. There is no question. I agree with you.
I was in the head of the legal team. That's what I'm trying to say. I was counsel, and I was responsible for all legal work. I took responsibility for everything that the legal team did. They did it under my direction.
Proceed.
As regards the investigation, I was not head of the investigator. I'm not an investigator. According to my engagement letter, these investigators were independent police investigators from the Office of the Inspector General of Police or from the FIU, Financial Intelligence Unit. If you look at my engagement letter, again, paragraph 2 is quite clear that paragraph 2 of my scope of work. The scope of the work which I have agreed to undertake is as follows. And 2, as regards investigation process and correlation of the evidence. So all my functions are set out, what I am required to do. And one of them is to coordinate the investigations to assure the quality of the evidence that is produced, to guide the investigators on the access and production of any matters of evidence outside the jurisdiction, assemble and present to the commissioners the evidence necessary for the conduct of the inquiry on the matters set out in the terms of reference of the commission. In this regard, all evidence is to be submitted to council, whether directly by members of the public or through the secretariat of the commission, or by any investigator supporting the commission. So I was working entirely in accordance with my terms of reference. Perhaps those who gave evidence here did not avert their minds to the functions or my duties under my terms of reference. I was not heading the investigations. I was coordinating it. And Mr. Chairman, if I may explain, perhaps something that is, I think it's important in terms of how the investigation was organized. Under the Commission of Inquiry Act, the commission, when it finished its work, would submit its report and its recommendations. Now, this was changed by the Constitution. Under the Commission of Inquiry Act, the Commission reaches its conclusions, makes recommendations, sends it to the President, and the President then decides whether to accept or not to accept and publish its report. Under the Constitution, 1997 Constitution, commissions of inquiry were kind of elevated to a different level. Now, under the Constitution, when the Commission reaches a conclusion, which I call its findings, then it has to categorize its findings as to what was adverse and affects someone else in a very substantial way and what wasn't. And those adverse findings are subject to appeal to the Gambia Court of Appeal. So in other words, it was not a simple question of witnesses appearing, giving evidence, the commission reaching a conclusion and sending recommendations to the President. All its conclusions must be conclusions that are supportable at law, meaning when they are challenged, because they are adverse, the matter goes to the Court of Appeal. Those conclusions, called findings, have to be defendable. So it was very crucial to have the services of counsel. Ordinarily, you don't have to have a lawyer in a commission of inquiry, but it became essential because of the 1997 Constitution that evidence that's put before the commissioners and on which they make a finding or a conclusion must be evidence that would stand up in law, that meet a certain standard. And we call it in law on a balance of probabilities. It's evidence that proves the allegation that that has been made against that adverse party. And so that's why it was important that as counsel, when investigators submit their report, I would look at the evidence and then I would give them advice as to whether that evidence, the standard of that evidence was good enough for the conclusions of their investigations. Because every investigation report would have conclusions and investigators would indicate what their findings are. So before it's presented to the commissioners, part of my role was to look at the evidence and to look at the weak areas, if any, and to say to the investigators, I don't think this is sufficient. I think you should look at this. I think you mentioned this particular witness, but you haven't really made out a case based on what you're saying. So go back and investigate it. So perhaps I needed to explain that. So perhaps to a layperson, it would look like, oh, okay, Mrs. Bensouda is head of the investigators then, and she's the one in charge of the investigation. I wasn't. Investigators, every investigator is independent. They would investigate, they would write a report. That report will be submitted. I'll look at it. If I think it was comprehensive enough, I'll compile the report and the evidence supporting the report, I'll present it to the commissioners. If I thought there were gaps, I'll send it back. But if it was but it was a dynamic process. You know, I can submit part of what they provide whilst they're looking at some other things. So I just want to explain so that there is no misunderstanding. But the investigators were not a body. They were just loose, independent persons taken from the police. Each of them had an area they were investigating. That is how it worked.
Okay, thank you for your guidance, Ms. Bensouda. Please direct us to the part of the Commission of Inquiry Act that you are referring to that differs with the Constitution.
In terms of, I did not, at least in my latest evidence, I did not refer to any part that differs with the Constitution.
I believe what you are told, the chair, is that previously.
Oh, I see.
Exactly.
Okay, I see what you mean.
Please direct us.
If you look at the Commissions of Inquiry Act, you will see under section 7, which sets out duties of commissioners defined. Section 7 provides that the commissioners, after taking the oath as prescribed, A, will make a full, faithful, and impartial inquiry into the matter in respect of which the commission is established, and conduct the inquiry in accordance with the directions, if any, in the commission. And this is the commission issued by the president. That's what is being referred to. There's the terms of reference. And B, in due course, furnish to the president in writing the result of the inquiry, including a full statement of the proceedings of the commission and of the reasons leading to the conclusions arrived at or reported. Now, if you look at that provision is in the Constitution. But in addition, the Constitution goes on, and in section 204, it has an additional provision that is not in the Commission of Inquiry Act. And it says, there are two additional provisions actually, but I'll start with the one that relates to what I have just read. Section 204 says adverse findings. 1, where a commission of inquiry makes an adverse finding against any person, it shall, at the time of submitting its report to the president, inform such person of the finding and the reasons therefor. 2, a person against whom any such adverse finding has been made may appeal against such finding to the Court of Appeal as of right, as if the finding were a judgment of the High Court, and on the hearing of the appeal, the report shall be treated as if it were a judgment. 3, an appeal under this section shall be made within 3 months of the appellant being informed of the adverse finding, as provided by subsection 1, or such later time as the Court of Appeal may allow. So, in other words, the commissions of inquiry did not have, before the Constitution came into force, they did not have this power. But by the Constitution, section 204, they were given the additional power of actually making a finding, actually saying, we find as a fact that this person has committed, for instance, I'm giving you an example, has committed what can amount to an offense under the criminal code, and they refer to that section in the criminal code. And if they do make such a finding, by this section, they have to serve before, when they are submitting their report to the president, they have to give notice of that finding to the person affected. And that person then has a right of appeal to the Gambia Court of Appeal, because that finding has the same importance as a judgment of the court, of the High Court. So that person can then appeal to the Gambia Court of Appeal against that finding. So that now place a huge burden on the commission, because it means that since the finding of the commission has been elevated by the Constitution to the same level as a judgment of the Court of Appeal, judgment of the High Court, it means that the evidence that the commission relies on in order to come to that finding, to make that conclusion, must be evidence that will stand the usual tests of such evidence in the High Court. Because when a judge of the High Court says, I find as a fact that you did A, B, and C, I find as a fact that you committed theft, it's because there's evidence on a balance of probability that's been placed before that judge. The conclusion has to be based in law. It has to be supportable in law. And that is why it was very crucial. My role as counsel was very crucial in making sure that not every evidence is just taken to the commission and said, okay, this is the evidence and that's it. I have to make sure that at least there's a balance of probability that that evidence, one, it's been properly obtained, and if it goes to the Court of Appeal, it will not be thrown out, and so on. So that was my role. Second, the second difference, and which is fundamental also, is in section 202, subsection 2 of the Constitution, subsection 2, D. Because if you look at the Commission of Inquiry, the Commission of Inquiry had the power to summon witnesses. Section 10 of the Commissions of Inquiry Act says that commissioners acting under this act have the powers of the High Court to summon witnesses and to call for the production of books, plans, documents, and to examine on oath witnesses and parties concerned, and to make interim orders. Okay, it's the same. Okay, sorry. The making of interim orders is the same. I thought there was a difference, but it's the same. The Commission of Inquiry had. So this is the main difference, is the adverse findings. But the interim orders, both acts provided for interim orders. I think I'm looking at the act. Yes. All right, Council.
Thank you for that, Ms. Bensouda. Now, what we were looking at was whether you were the head of the legal and investigation teams or not. And evidence to the contrary has been registered on our records as a committee. And we wish to just put that to you. That's where we were. You've directed us to paragraph 4 of your MOJ 3K, which is your engagement letter to the government. And I believe you also read paragraph 2, didn't you? If not, let's look at paragraph 2. Shall we? Shall we? Paragraph 2.
Sorry.
Let's look at paragraph 2 of your engagement letter, MOJ 3K. And paragraph 2 says, the investigation process and correlation of the evidence. Perhaps let's get context of that before. Perhaps I can allow you to go through paragraph 2 for us and explain each of the paragraphs under paragraph 2, the sub-paragraphs rather.
Paragraph 2 is self-explanatory. Do you want me to read it?
Please.
Right. The investigation, paragraph 2 is paragraph 2 of the scope of work on the engagement letter. And I'm reading from the bundle I provided. I'm assuming that the bundle, I think it was tendered in evidence.
Yes,
Yeah.
but just for the purpose of the chairperson and the committee members, it is MOJ 3K.
Very well. Scope of work. The scope of work, my scope of work as lead counsel was divided into 3 main areas. And the 3 areas are: 1, the management and administration of inquiry process and procedures; 2, the investigation process and correlation of evidence; and 3, the proper and effective conduct of commission hearings, whether in public or private as appropriate. And paragraph 2, which is the investigation process and correlation of evidence, has 7 subparagraphs, A to H. And A says, identify the evidentiary issues, the order in which they are to be pursued, and the approach to be taken in pursuing them, as well as the witnesses to be called. B, coordinate the investigations to assure the quality of the evidence that is produced. C, to guide the investigators on the access and production of any matters of evidence outside the jurisdiction. D, assemble and present to the commissioners the evidence necessary for the conduct of the inquiry on the matters set out in the terms of reference of the commission. In this regard, all evidence will be submitted to council, whether directly by members of the public or through the secretariat of the commission or by any investigators supporting the commission. E, to correlate and present all evidence and other material in a coherent and efficient way. F, to determine the selection of witnesses to give oral evidence, the order in which they will be called, and their allocation to different issues within the terms of reference, and to submit to the secretary witnesses to be summoned. G, to review all evidence and exclude and minimize the risk of unreliable evidence motivated by malice or bad faith being released into the public domain. H, to act as a filter between the investigators and the commissioners by, among other things, ensuring that results of investigations are properly supported before presentation to the commissioners.
After reading paragraph 2, Ms. Bensouda, can it be said that you did not direct the investigations team?
I did not direct the investigations.
Okay, if you can look at the paragraphs a bit closer, or rather,
And if
perhaps,
if I may add,
please.
and it doesn't matter to me what anybody says about whether I directed the investigations or not, because it's entirely irrelevant. This commission is over, it's functus, it has done its job, it has submitted its report. I appeared before it, I have done my job, I have submitted my report. So opinions, persons can hold opinions. Now you have asked me, did I head the investigations? I said no. Now you're asking, can it be said that I did not direct the investigations? I'm saying I did not direct the investigations. And as far as I'm concerned, that is of no moment. Thank you.
Thank you, Ms. Bensouda. Unfortunately, for me, I have a job too, which is not functus, it's active, and it's to probe in these specific issues. So unfortunately, I have to ask these questions, and unfortunately for you, you would have to answer these questions. I wish to look at some of these. Sorry? Oh, okay.
I'd just like to,
Sure.
for the record again, to say that the tenure of all these questions since this morning, or since I started appearing in, before this committee, I did raise the concern, and I'd like to raise it because it's a matter of record. And I'm saying that all these questions are way outside the mandate of this committee. The committee's mandate is not open-ended. This committee is not been set up by the National Assembly to review the work of the Janneh Commission. That is not in the motion that was passed on the floor. I don't see it there. And nothing in that motion supports what is happening, the tenor of the questions that are being asked. And the committee is subject to judicial review, to my mind. And at the end of the day, we expect that it will produce a report that is consistent with its mandate. So, yes, I've been invited to answer questions, but I do have privileges as a witness. I should not be asked to answer questions that are not within your jurisdiction, which is your mandate is all about, and which is your remit. So I'm here. I will give my best to cooperate with the commissioners. But I think that all these questions, and I don't want to make any statement that questions your work, learned counsel and learned friend. I'm not questioning your role, but I'm drawing your attention to the importance of any committee staying within its jurisdiction. Because staying outside that jurisdiction can tantamount to abuse of authority and abuse of power. And you know this.
Indeed, I know this, and I do appreciate this, Ms. Bensouda, and I'll agree with you that the committee going out of the whims of its mandate would be an abuse. I would disagree with you that we are going out of our mandate. And I believe this issue has already been raised and an order been given. So if we could proceed, since you've done us the kind courtesy of answering our questions, I would continue to say paragraph 2. We look at it, if we look at it, and perhaps if I may note, just from counsel to the witness, that you see, the responsibility of the National Assembly extends to advising the president on policy, on the president's policy considerations. And while the mandate is clear, anyway, let me stop at that. The Assembly should advise the President on policy issues, and this work, your testimony, will go a long way in enabling the Assembly to do that. Thank you. Paragraph 2, the investigation process and correlation of evidence. Now, the first limb talks about identification of the evidentiary issues. And then when you go to B, it says that you are responsible for coordinating the investigations to ensure the quality of evidence that is produced. C says that you are responsible to guide the investigators on the access and production of any matters of evidence outside jurisdiction. D says that you are also responsible to assemble and present to the commissioners the evidence necessary for the conduct of the hearing. Now, a wholesome reading of paragraph 2 indicates that, indeed, the investigation team were under you. Any comment?
No, I don't have any comments. You're entitled to whatever opinion that you form.
Certainly. Certainly. I would ask the Secretariat to also furnish the witness with SC6. SC6, but in the witness can also, since the witness has a bundle, can look at MOJ 3G and MOJ 3O and O. SC6, Secretary to Cabinet 6. O.
SC. I know the volume itself is SC, but how do you? Okay. Oh, you're going by the folio. Okay.
Honorable Chair, can I proceed? Thank you. Let's begin with SC1, which is SC6 rather, which is a letter dated the 20th of July 2017, just days after commission was set up, and precisely 3 days after you resumed work, because you've informed the committee that you resumed work on the 17th of July 2017. Now, this is a letter that...
I assume.
Sorry?
I
assumed rather, my apologies, yes. You assumed work on the 17th of July 2017. 3 days later, a letter was issued from the commission to the office of the president under your hand. I will allow you to give us the contents of the document.
Mr. Chairman, this letter is in the bundle of documents I provided also. It's reference COM/CL/volume 1/09 dated 20th July 2017. And this is one of perhaps, I don't know whether it's hundreds of letters I wrote to various institutions.
Could you help us, please? I'm not sure the mic is going. Or could you, yeah.
As I was saying, this is one of a series of documents I wrote to various institutions and organizations when I assumed my duties on the 17th of July 2017, and this letter was dated 20th July 2017. In my bundle, I have given what I call examples to show what I was doing during that period. So the letter is addressed to the Secretary General, Office of the President, State House, Banjul. And for the record, it was Mr. Fadera who was Secretary General and was very helpful in our investigations. And it says, "Dear Sir, the Commission investigations. As you are aware, I have been appointed counsel to the above commission, which has started work from the Jembe Beach Resort, formerly Jema Beach Hotel, Kololi. My duties include the coordination of the investigations and compilation of all evidence relating to the TOR for presenting to the Commission. In this regard, it would be greatly appreciated if the following information could be submitted to the Commission as a matter of urgency. 1. The names and contacts of all persons who have served as Secretary General, Cabinet Secretary, and Chief of Protocol from 22nd July 1994 to 21st January 2017, which was our mandate. 22nd July 1994 to 21st January 2017, the period during which they served, their current whereabouts and contacts if known. 2. All remuneration, including salary, allowances, gratuity, and pensions earned by the following persons during the aforesaid period: ex-President Jammeh, Lady Zainab Jammeh. 3. The bank and bank accounts into which the remuneration were paid. 4. The payment vouchers and any other supporting documents for the payments. And it goes on to say, it would also be helpful if a suitable officer from your office could be identified to work with the investigation team in order to facilitate interface between your office and the inquiry and the retrieval of necessary information. Please note that this request is urgent, and we would appreciate receiving the information on item 2 and 3 in particular before the 28th July 2017. I count on your cooperation. Yours faithfully, and I signed Ami ND Bensouda. Copy, Secretary to Commission.
Let's look at MOJ 3O and 3G as well, because they're under the same belt.
MOJ 3.
3G and 3O.
MOJ 3G. Can please, can I be assisted?
If the Secretariat could assist the
If
witness.
it's in this bundle, I'm not sure.